Hello, everyone. Hoping that you are all well. I'm going to start tonight by doing an acknowledgement of country. We are meeting today on all of the lands that we're meeting as Aboriginal land. I'm coming to you from Gadigal country in the Eora Nation and pay my respects to elders past, present and emerging. I'd like to thank Gowland Legal and Bartier for partnering with us for this important event, and to Sarah Judd, who's been coordinating our Women's Safety Advocate Program, and Anna Pose from Bartier, who's been doing a lot of work behind the scenes to make this happen. And thanks to each of you for taking time out of your very busy lives to join us. We are hoping today to provide you with some legal information to assist you in telling your story safely. We know that it's only through diverse women sharing their experiences and through our collective action that we can drive the changes that we need to see as humanly possible to end violence against women and their children. You'll hear today from Jennifer Shaw, partner with Bartier Lawyers, who will take you through some of the ins and outs of defamation law. And then Lyndall Gowland, Principal Solicitor of Gowland Legal, who will take you through some of the key aspects of domestic violence, family law and care and protection law. We're then going to have some time for Q&A, but feel free to send your questions through in the Q&A at any time, and we'll come back to you when we can. I'll be kind of moderating behind the scenes. Now, just a couple of notes. While this information, it's an information session, it's just that, information that you can apply to your own situation, and note that it is not individual legal advice. We recommend that you obtain legal advice prior to speaking out about your experiences, and we're happy to provide you with referrals for this upon request. Please note also that some of the content today, such as examples and case studies that are provided by our speakers, may be understandably. Feel free at any time to get up, have a break, have a cuppa, and come back if and when you feel like it, and check in with your people and your supports, and of course there's always other services like 1-800-RESPECT. So all this also goes for when you actually go out and tell your story publicly, and some of you are very experienced advocates, some of you may not have spoken out before, but I guess what we would reiterate is that your safety and support must be your absolute priority, as it is ours, and this applies whether it's before, during or after you've gone out and told your story. That we need to make sure that it's a safe experience. We'd also encourage you to participate in some of our upcoming media training before, to assist you in telling your story in a safe and empowering way as much as possible. And yeah, I guess the other point to make is that this session is being recorded and will be subsequently made available to you afterwards, along with the slides from Jennifer's presentation, and also Gowland. Lyndall is going to be able to provide you with some fact sheets as well. So we'll also send through a short survey afterwards to see if you found it useful, and you have any other suggestions, and also suggestions for future workshops you'd like to participate in. So with all that out of the way, I would love to introduce you to Jennifer Shaw. Jennifer is a partner at Bartier Lawyers in the Dispute Resolution and Advisory team. She has over 20 years of experience in the legal profession. Her practice has a specific focus on professional responsibility and conduct and litigation and dispute resolution. Jennifer commenced her legal career overseas and has also been admitted as a solicitor in England and in Wales. Please welcome Jennifer.
Thanks very much, Hayley, for that introduction. So I'm going to provide you with a general overview, the basics of defamation law in Australia. I'll also talk to you about some defamation court cases where defamatory material considered in those cases concerned allegations of domestic violence. So in this presentation, we're going to look at what is defamation, what are the key elements to a defamation action, who can bring a claim, some of the defences, damages, some upcoming changes to the defamation law, and some case studies and a few key tips and takeaways. So let's start by what's meant by defamation. Defamation is a communication from one person to another person which harms the reputation of a third person. It's any statement that would make a reasonable person think less of the person who is the subject of the statement. So defamation law has to balance the right of free speech with protecting a person's reputation against harm. And whilst we often hear of TV programs and newspapers being sued for defamation, people have also sued over books, cartoons, photographs, Facebook posts, and Google reviews, just to name a few. In Australia, each of the states and territories have largely uniform defamation laws that were enacted in 2006 that coexist with the common law rules as to defamation. So the law in defamation is similar across Australia. To be successful in a defamation action, the plaintiff has to, and the plaintiff, that's the person suing, must prove three things. That the material must have been published in some shape or form to a third person. The communication must identify the plaintiff or be about the plaintiff. And the meaning of what was said must be defamatory and damage the person's reputation. So let's have a look at those three elements in a bit more detail. So publication to a third person. Well, publication can occur by any means. It can be in writing, it can be verbal, can be in pictures, and it has to be published to at least one other person other than the person being defamed. Everyone involved in the publication is potentially liable, and the intention of the person publishing the defamatory material is irrelevant. So what about if you republish material? Well, it's no defense to argue that you were just repeating a comment that had been made by someone else. You can still be held liable. And liability can also arise if you fail to remove defamatory material, even if you've innocently disseminated it. If you're being asked to remove it and you fail to do so, you can be held liable. So the next element, the communication has to identify the plaintiff. So a communication doesn't need to refer to the person's name to satisfy this element. Rather, a photograph, a nickname, or another description leading to the identification of the plaintiff will suffice. The plaintiff has to prove that the publication identified them, and to do that, the courts apply the ordinary reasonable person test. So in other words, the plaintiff must prove you were talking about them, and a reasonable person would assume this. A statement denigrating a group may be defamatory of a member of that group if the group is small enough. So for example, if you say that all lawyers are crooks, that group's too large, so unlikely you'd defame anyone. But if you were talking about a football team or members of a board, that might be defamatory of someone that's in that team or on that board. The next element, the meaning of the communication has to be defamatory. So the test for this element is, does the communication lower or harm the plaintiff's reputation? Does it hold them up to ridicule? Does it lead others to shun or avoid them? And must affect their reputation in a damaging way. The meaning of the material is considered in the context of the entire publication. Again, the test is the ordinary reasonable person test. So what the ordinary reasonable person viewing the material could have understood the communication to mean. So who can bring a claim and where and when? Well, any person can sue for defamation against anyone involved in the creation, publication or dissemination of the defamatory material. A non-profit corporation that's not a public body can bring an action, and so can a company employing less than 10 people. The plaintiff commences their action in any state or territory in which the communication was published to a third party. A plaintiff would usually sue in the closest court to their home address or place of work where their reputation is best known. The action has to be brought within 12 months from the date of the publication. So what about some defences? Well, there are a number of defences under the Uniform Defamation Laws that are available to a person who's accused of publishing defamatory material. Some of the key ones are honest opinion. So the defence of honest opinion requires you to prove in a nutshell that the material communicated was an expression of honest opinion rather than a statement of fact on a matter of public interest and based on proper material. Justification, truth. At common law and under the Defamation Act, a claimant is not permitted to recover damages for an injury to a character which he doesn't possess or ought not possess. And so for this reason, a successful plea of justification is a complete defence to a defamation claim. For the defence to succeed in court, you have to prove that the defamatory stings are objectively true as a matter of fact. You don't have to prove that every word you publish is true, but you must establish that the essential or substantial truth of the stings of the defamation. And the challenge, of course, to that defence is that you can only rely on admissible evidence to prove an imputation is true in substance, such as credible first-hand witnesses. So you need to consider how are you going to prove the truth if it goes to court. Qualified privilege. This defence traditionally protects communications, for example, if you're reporting matters to the police or other relevant authorities. The defence of qualified privilege can't be used, though, if the defamation was motivated by malice. Innocent dissemination. So, for example, a newsagent selling magazines with defamatory material would be able to use this defence. Triviality, and there are various other defences, contextual truth, absolute privilege, which, for example, is words said in Parliament or in court proceedings, fair reporting, and so on. So damages. Well, when a person sues another for defamation, they're usually seeking money for the personal distress and hurt caused by the publication. The sum awarded is generally at least the minimum necessary to signal to the public the vindication of the person's reputation. So in assessing damages, the court will consider the extent of the publication and the gravity of the allegations. You can also seek damages for economic loss. So if they've lost their job as a result, for example, or they're unable to find further work as a result of the defamation. A defamed person can also seek aggravated damages, which are awarded in a court when a person's conduct is so outrageous that an increased award is necessary to compensate the exceptional harm caused by the defamatory publication. Another thing that sometimes people seek is an injunction. So if the defamatory material is still circulating, an injunction can be sought to prevent ongoing publication. There are some upcoming key changes to the defamation laws. The laws in Australia haven't changed since 2006, but in August this year, the Model Defamation Amendment Provisions 2020 were passed in New South Wales, but they haven't yet been enacted, so they're not yet the law. But some key changes will be, when they are eventually enacted, that serious harm will be introduced as an element, which means that the person claiming defamation will need to show that the publication has caused or is likely to cause serious harm to the reputation of the plaintiff. And the effect of that obviously remains to be seen, but presumably it might limit the number of defamation claims in the future, or at least weed out the trivial ones. There's also a new defence of public interest, a new defence of peer review, a single publication rule, so the limitation period of 12 months to commence an action for defamation will only apply from the first time the material is published or downloaded. So if material continues to be downloaded in the future, the limitation period doesn't restart each time. And the amount for damages is currently, I think, $250,000. So that hasn't changed. This is for non-economic loss. But the new provisions say that this is a scale, and the full amount will only be awarded in exceptional circumstances. So as I say, note these changes are yet to come into force. So as you can imagine, there have been numerous cases in the courts which deal with defamatory material that relates to domestic violence allegations. I'm now going to discuss some case studies on the topic, I'll be discussing these for about 10 minutes. I'm not going to go into too much detail about the domestic violence allegations, although the first case is a very tragic case. So if you do think you might be triggered by listening to this, any of these cases, then feel free to go and make a cup of tea and skip this bit of the webinar and come back in, say, 10 minutes or so. So the first case, this was a really tragic case where a mother took her own life along with her 5 children. And the father eventually agreed to be interviewed to raise funds for the funerals. And he provided some photographs of his children to the magazine New Idea for a one-off publication, which went ahead. But some years later, about 7 years later, the Sunday Times published 2 articles and focusing on the rising number of domestic violence cases in Western Australia. And after the first publication, he contacted the newspaper to complain and to say he didn't give permission for the paper to publish the photographs. But undeterred, the paper ran another article about a week later, also featuring the photograph of his children. So he brought proceedings against the Nationwide News for various causes of action, including breach of copyright in the photographs and defamation. So he claimed the material was defamatory because, amongst other things, it imputed that his children were murdered as a result of domestic violence, and imputed that he himself engaged in domestic violence because the material quoted police sources that many victims of domestic violence kill themselves to stop the abuse, and because it failed to qualify that comment by saying that he had never or never been alleged to have engaged in domestic violence. The court said that in determining whether a defamatory meaning can be imputed, it's necessary to consider the 2 articles in context as a whole, including the headlines, photographs, and other material. And the court said it's clear that the articles say that the applicant's 5 children were murdered as a result of domestic violence, but the articles make it equally clear that the children were murdered by the applicant's former de facto partner. So the court went on to state that a person reading those articles reasonably and without a strained, forced, or unreasonable interpretation would not read the articles as imputing that the applicant had any involvement in domestic violence or the murder of his 5 children. So the court dismissed his claim for defamation, but he did win damages for breach of copyright. Next case, in this case, this concerned a Today Tonight segment, which related to Mark McGaw, a former rugby league star. The programme included an interview with a woman who provided details of injuries she claimed to have sustained from alleged abuse. It was broadcast to over 1.37 million people across Australia. He commenced proceedings in the New South Wales Supreme Court against Channel 7 for the publication of defamatory material. And the jury found that the broadcast gave rise to 2 defamatory imputations against him, that he was a man of dangerous domestic violence, and that he bashed his lover so severely that she was hospitalised with horrific injuries. So he sought damages, including aggravated damages. Channel 7 sought to argue that the first imputation was true, and that was under the old legislation, so they also sought to argue that it related to a matter of public interest, and that the second imputation was contextually true. But the court said that the truth of the imputations depended very much upon whether one believes that which was said in the interview and in the evidence by the woman, or whether one believed Mark McGaw. And the court accepted the evidence of Mark McGaw and said it did so without hesitation. The court held that the woman was giving a version of events that was inaccurate and untruthful, and that her account differed between evidence she gave in court, the statement she made to police, and the interview with Channel 7. So Channel 7 were ordered to pay damages in the amount of $385,000 to Mr. McGaw, and the court said that in this instance, it's difficult to imagine a defamation that would have more profound or worse effects on a plaintiff than this one. In those circumstances, the level of damages must be in the highest order and must properly compensate the plaintiff for his hurt, his distress, and the harm done to personal and business reputation. And the third case study, in this case, the plaintiff, in this case, alleged that the defendant had posted on her public Facebook page an entry that said, "Separated from Mira Dabrowski after 18 years of suffering domestic violence and abuse, now fighting the system to keep my children safe." The plaintiff alleged that the post was up for 6 weeks or about 6 weeks, and the post was defamatory. The defendant denied that she published the post and said that if she did, the post did not have defamatory imputations, and if they did, then she relied on the defensive justification. But the court held on the balance of probabilities that the defendant did publish the post and then removed it at a later date after she received a concerns notice, and they rejected her evidence to the contrary as simply an effort by her to avoid the consequences of her actions. But during the proceedings, the court heard evidence from both parties, which included various allegations from the defendant that her ex-partner had subjected her to domestic violence and abuse. The court found that the Facebook post was defamatory, and in fact, if her evidence was accepted, then it would establish the substantial truth of her claims. But the court did not accept her evidence as being credible because of inconsistencies in her evidence and the court documents filed by her. The court held that she had a propensity to say whatever advanced her case. The court held that she had not proven on the balance of probabilities that the plaintiff subjected her to 18 years of domestic violence and abuse, nor that the children needed to be kept safe from him. In fact, the court said that her credibility is so badly affected by the matters to which I've referred that it leads to the conclusion that she's prepared to say or write whatever she thinks will suit her case, and he wasn't prepared to accept her evidence at all. And finally, you may have heard of you may have read very recently about the Johnny Depp case. So although this case is not Australian, some of you might be familiar with it. The Sun newspaper published an article about Johnny Depp with the headline, "Gone Potty, how can J.K. Rowling be genuinely happy casting wife-beater Johnny Depp in the new Fantastic Beasts film?" So Johnny Depp brought proceedings against the Sun's publisher and the paper's executive editor. The newspaper relied on the defence of truth under the UK defamation legislation, but the court dismissed Johnny Depp's claim and held that the defendants had shown that what they published in the meaning which the court held the words to bear was substantially true. It remains to be seen whether Johnny Depp will appeal that decision. So finally, some key tips and takeaways. I think consider the benefits of publishing against the risks of being sued. Consider any material as a whole and consider the context and try and put yourself in the position of the potential plaintiff viewing that material. Remove any identifiers from material so that the person is not easily identified. Consider potential defences that are available. So if you want to argue that what you're saying is true, consider how you're going to prove that. If you're giving an interview, perhaps request a list of questions and prepare some scripted answers, and maybe even seek advice about those scripted answers before you proceed. Also, beware of social media. I saw that Domestic Violence Chief Executive Domestic Violence New South Wales Chief Executive has stated in the past that an increasing number of domestic violence victims will post allegations and sometimes graphic content on social media. And it's important for individuals to be mindful about what they post on social media, which includes sharing or reposting another person's content. And finally, if you're threatened with action for defamation, seek legal advice. Thank you. I'll pass over to Lyndall.
Thank you so much, Jennifer. I'm sure we'll all agree that that there is so much more to this than first meets the eye, and a lot to consider when it comes to being mindful around defamation law. The next wonderful speaker that I'm going to introduce to you is Linda Gowland. Linda Gowland is the principal solicitor at Gowland Legal. She's a survivor/flourisher of 20 years of domestic violence. She's admitted to the New South Wales Supreme Court and the High Court of Australia. She has a Masters of Family Law, an independent children's lawyer accredited, and she also has extensive experience across the family law, child protection and domestic violence fields, with 10 years in CLC, Community Legal Centre, including Women's Domestic Violence Court Advocacy Services, 3 years with the Aboriginal Legal Service, 5 years across regional, rural and remote Australia for Indigenous family violence prevention legal services. And in 2010, she established Gowland Legal Family Lawyers, dedicated to protecting women and children from domestic abuse. In 2016, she founded the Gowlands Awards, which some of you might know about, which are held annually to acknowledge the strength of survivors and of domestic abuse, and to celebrate the remarkable achievements of frontline domestic violence workers. And indeed, this year, she also founded Lawyers Against Domestic Violence and Abuse to educate the legal profession and promote law reform and provide collegial support to those supporting people experiencing domestic and family violence. Without further ado, I'm going to pass you on to Linda.
Thank you, Hayley. I'm giving each of you a round of applause, because tonight we celebrate you for getting your truth out, for sharing your stories. It requires an enormous amount of bravery. It is not easy to put yourself out there and be vulnerable, especially when the subject is something that can carry so much stigma, so much risk. Give yourself credit for being strong enough to speak out, to speak about what you have been through. There can be an enormous amount of power in sharing your truth, your story. And tonight, what we're going to look at together is the family law obstacles for telling your truth, and also the tips for telling your truth. So, you've just separated before family law proceedings are involved. Can your public statements be used to say you do not put the children first, that you are a liar? If there are no proceedings before the family court, technically you are at liberty to say what you want. However, you need to be aware that what you can say can be used later as evidence in any future family law proceedings. Doesn't matter how far in the future that may be. Always act as if you may end up in the family law courts. In deciding parenting arrangements, the family law courts consider who puts the children's needs first and looks at a party's credibility. A party's credibility is critical. Statements made by parties on social media, as Jennifer talked about earlier, are very popular, but are often used to support a case in the family court. The family law courts will accept social media activity as evidence. There is an interesting case where the father produced evidence from Facebook about a relationship between the mother and her new partner. Now, the relationship on its own was of no problem, but the problem was for the mum was that she had continually said there was no such relationship. There was evidence on to the judge, to the court, to say there was no such relationship. And then the dad presents his evidence from Facebook that showed the mother absolutely was in a relationship with this person. So why that was critical? Because immediately the mother looks like a liar. The mother's credibility is out the door. Especially important, you will all know, when it's a matter of domestic abuse, it is so often your word against theirs. So your credibility is critical. Therefore, if you publish your story, it is important to ensure that it's accurate and that you have sufficient evidence to back it up. Additionally, there may be effects on any future family law case if you speak negatively about your ex. There was a case, Kester versus Schultz. In this situation, it was the mother's evidence. It supported the mother's case. That's good news, but it shows that social media can be used to your detriment in court. So what happened was the father's new partner had posted on Facebook that she mentioned that she'd like to go on a killing spree. That Mr. Schultz's ex, so her partner, so Mr. Schultz's ex is pissing me off. So the court looked at that, and there was the evidence that the parties were abusive. There was domestic abuse from the father and his partner to the mother. Clearly, it is important when telling your story that you ensure it cannot be used in later legal proceedings against you. Okay, you're in the family law courts. You couldn't manage to keep away from the courts, you're in the courts. So what happens here? Section 121 of the Family Law Act. Section 121 will become burned in your brain, unfortunately, because whilst it does permit publication of family law proceedings, it does in a very limited manner. You are not to identify the parties. You are not to identify their relatives, their de facto spouses, their witnesses. It is not allowed to be an attack on the court. In simple terms, anyone who puts out information to the public which concerns family law proceedings may be guilty of a serious criminal offence. This section, Section 121 of the Family Law Act, applies equally to parenting, property, child support and divorce proceedings. It applies whether you're in the family court or if you're in the Federal Circuit Court of Australia. Most survivor advocates groups view this as a gag on survivors getting their truth out, that it effectively silences survivors of the family law system, that it prevents transparency in the family law system, that it prevents survivors from speaking out through the media. Survivors, the best protection is to take the matter to court and get the leave of the court, the permission of the court to tell your story. However, that is an expensive, arduous, time-consuming process and won't necessarily be successful. The other side, the competing view about the benefits of Section 121 is that it strikes a balance between the ability of people to tell your story and the ability to protect children from being publicly involved in the storytelling. Now, a lot of you will remember the Italian children's case. Now, it's a good case study of ways that one story can be told in ways, different ways. Can be told in a way that complies with Section 121, doesn't breach the family law, and the same story can be told in a way that it does breach the family law. So in that Italian children's case, a newspaper campaigned for the mother who she had unilaterally relocated her children from Italy to Australia. The newspaper put the photographs of the children on the front page and it ran quotes from the children. the paper and the editor were convicted and heavily fined under Section 121. However, go over into TV land, they did a better job of protecting this story, this truth. They complied with, the TV programs complied with Section 121, even though it was in different ways, which I will explain. One TV program told the mother's truth only from the point of view of what had happened during the family court proceedings, but did not identify the parents nor the children. It complied with Section 121. The other TV program told the story, the truth, by interviewing the parents and the children and other family members on camera, but did not refer to the existence of any family court proceedings. And that complied with Section 121. The mother was not in breach of Section 121. Now, the family law's idea of publication, what does published mean? I think you get the idea by now. Section 121 imposes a huge prohibition on the publication of any family law proceedings. It reaches far and wide. Publication in a newspaper, on the radio or television, by any electronic means, which of course includes all forms of social media, including every single one of your social media friends, regardless of how many or how few. And a general prohibition on sharing the information to the public or even a section of the public. The Family Law Court's view is that publication, the definition of publication is a widespread communication with the aim of reaching a wide audience, an audience wider than your immediate circle of personal friends, of your intimate family, your close family. So the case law suggests that conversations between your friends, your close friends, regarding just the family court proceedings is okay, is not a breach of Section 121. But you put that same information out to all your social media friends is probably a breach of Section 121. The family law's idea of identification. It is unlawful to publish information that identifies any person who is a party to the proceedings or who is otherwise connected to the proceedings. This may be perfectly obvious, but posting a name, including a made-up name or an alias, photographs, or even recordings that you had obtained with the other person's consent, all prohibited from being publicly shared. But it is critical to understand that the identity of a person is not just limited to their name. You can commit an offence if you release information that is sufficient to identify that person to a member of the public, including just a description of their physical appearance, their style of dress, the details of their address, their type of employment, personal relationships, business relationships, interest in recreational, religious, or even political affiliations, what they own, what real estate they own, what personal property they own, and even their culture are all seen as being ways that could identify a person and therefore must be excluded from any sharing of your truth. The family law has protected information. What is the information that cannot be published? Anything regarding the proceedings, including documents and information. All information gained, all documents prepared during family law proceedings, such as the family reports, subpoenas, mediation reports, discussions in mediations. For any of you that have been through family law proceedings or in a minute, a lot of this will be, the terminology will be familiar to you, but if you've avoided the family court so far, then I apologise, but these terms will be foreign to you. However, as a rule of thumb, you should treat every document, every piece of information that comes into your possession as a result of family law proceedings as private and confidential, meaning that it is not to be disclosed to anyone, not even family or friends. But first of all, let's talk about documents. Let's talk about the confidentiality of documents. In another law case, a case of Sandex, the mother showed 2 family reports and the psychologist report to an advocacy group that had been her support. She had the advocacy group critique the reports for her, and she attached their critiques to a statement to the court, to the affidavit to the court. She was self-represented, she did not have a lawyer. It appears she was not aware of section 121. So what happened was the judge told her that she was in breach, clearly in breach of section 121, because she shared the documents, and as a result of her actions, people the advocacy group was able to identify people that were involved in the case. The judge told her, clearly stated that she could not show any of the documents to anyone outside of the proceedings without the leave of the court, without the permission of the court. The judge went even further and said, under the Act, the court is very, very strict on protecting the privacy of parties, particularly children, to proceedings, and does not allow publication, which has a very broad interpretation, does not allow publication of anything that would enable parties or children to be identified unless the court has consented to that taking place. Now, the judge went on, the Act is very serious. The Family Law Act is very serious about this, and the Family Law Act requires that anyone who commits such an offence is punishable upon conviction by imprisonment for a period not exceeding 1 year. That's how seriously the court takes it, the judge finished. In this case, the mother received a warning, just a warning, because the judge accepted that she did not breach section 121 deliberately, and that she was self-represented. Now, let me share another case with you that shows information can't be published. So in the case of Lackey, the father made lots of posts, Facebook posts, about the mother, the father and lots of his friends and family. And the judge was very critical of the father's actions. And in that context, the court found that the court made parenting orders to protect the father from the children. and it resulted in the father having no time with the children. That wasn't just because he had been publishing all his information, it was because there was other factors about the father's capacity to parent. But the final result was that the father was not to have any time with the children. How long is the family law section 121 gag? Forever. It's important to remember that it applies during family law proceedings and is perpetual, meaning unless you obtain a family court order, section 121 will always apply. The consequences of a breach are twofold. Not only is there a high risk that the contents of your post could be taken out of context and used against you, it is also an offence that is punishable by imprisonment for up to 1 year. The court can issue a restraint from publication. You might, if your ex takes that action, you might end up paying their legal bill for the cost of the application. The court could ask for the material to be moved. The court can ask for the matter to be referred to the police for investigation. Another way that the court can impose a penalty is if it finds that a person is in contempt of the court. And again, that is taken very seriously. And again, it can be fines and imprisonment. But let's get the truth out. Let's get the truth out. When sharing your story, the following are good ways to protect yourself. Clearly, de-identify. Look at works with authors, journalists who offer a trauma-informed practice. For example, Jess Hill's book honours the abuse, honours the survivor. Dr. Julia Baird and Hayley Gleason are equally reputable journalists, and there are many of them. Obtain the court's permission. Pre-approve all questions. Make sure your agreement with the media company protects your confidentiality. Ensure you retain the final say on what is published. Remember, once anything is posted online, you lose control. If you are unsure of your obligations, seek legal advice. To conclude, as we close, Jess Hill's book, See What You Made Me Do, shows that survivors' truth, your truth, can be told in a meaningful way. As Jess Hill says, we need to show it like it is. So again, I'm clapping you now for surviving all that legal jargon. Stay safe.
Thank you so much, Lyndall, and thank you, Jennifer. I hope everyone gleaned some pretty important tips from that. I know it was a really good refresher for me as well. I just wondered if anybody had any other questions. Please pop them in the Q&A or the questions box there. I do have a few already for you, Lyndall. So the first one is there an equivalent gag order in the criminal court?
I'm not a criminal lawyer, so I can't answer that. The criminal laws are very different to the family court. The family court is particularly onerous with section 121.
And did you have anything that you wanted to add to that, Jennifer, or perhaps we do?
I'm also not a criminal lawyer, but I probably make the observation that if there's been a public judgment in the criminal courts, it tends to be published in the press. So I'd have thought that that is something that's able to be published. But look, I don't know. I mean, I don't know about any gag orders. If you're involved in criminal proceedings that haven't been finalised, I'm not a criminal lawyer. There's a general kind of rule about not speaking to the press, I think, during proceedings, because it might impact on the administration of justice, and that sort of applies to any court proceedings really. So generally we discourage our commercial clients, for example, from saying anything during proceedings until there's a judgment. But once there's a public judgment, certainly in civil cases, it's okay to publish that judgment. So I'd have thought it's similar to with criminal matters, but I don't know.
Yes, so I'm avoiding giving anyone legal advice, but that's certainly what we've heard, is what Jennifer's saying, and might be when the suggestion box, the feedback that comes up at the end, it might be something that you might want us to cover in another session about things like non-disclosure orders and agreements that are made as well as part of that, because there are open court proceedings, and then there are other aspects that sometimes part of the agreement is that there is non-disclosure, and also child protection as well. I don't know if you want to say a few words, Lyndall, about child protection legislation now, or is that perhaps something we do in another session?
Well, child protection is very similar to family court because it's all about children. So the court's premise is that it's all about protecting children's being put through the ordeal of their situation being exposed publicly. So, you know, that's my view of child protection, given that you really want to see if what orders people had. People might have a particular order made through the children's court that puts a particular onus on the parents, but generally the fundamental principles are the same. The protection of children.
We've got a really interesting one here, and that is, just grabbing it up here. So what about one party showing legal correspondence between the parties to a person that's actually the client of the other party? So in other words, they have shared that legal correspondence to somebody who would be connected with the other party's lawyer, so as to just disparage that other party to their own lawyer.
Sorry, say that again, Hayley.
Yes. So if you had legal correspondence between two citizens, one of the parties.
Yeah.
Okay. One of the parties shares that private and confidential correspondence with the other party, like with a client of the other party's lawyer. Yeah.
Or just with a third person, so not one of the parties. Is that what you mean?
That's right.
In a family law context.
Is it a family law context? Well, there's there's a couple of issues there. There's the waiving of legal professional privilege too, by showing your communications between your lawyers. If that's what's happened, they've shown their legal correspondence to somebody that isn't a party to the proceedings.
Depends if it's correspondence between the solicitors, which would not be privileged, or whether it's correspondence between them and their solicitor, which would be privileged, if you follow.
Right.
So correspondence between the client and lawyer would be privileged.
But correspondence between the two lawyers?
I'm not quite sure I fully understand the question.
No, I don't either.
Might be a follow-up one.
Yeah.
Maybe. So that might we get some more clarity on, but very convoluted. Yeah. I've just got one here as well from one of our participants saying, why is section 121 so extreme?
Good question. It is the one, as I said, there's one school of thought that it's about protecting children, but the evidence against that is that it protects people in, it applies when you're in property proceedings or a divorce, when there's no children. So, there is that, it started, it was a part of the initial Family Law Act in 1975 as a reaction to the old Marriage Act, where publication was allowed, was rampant, and it was horrendous. That really, you'll see the old photographs of the people coming out of the divorce courts, and all the people, all the lurid details were, you know, were on every front page of the newspapers, and apparently the Daily Telegraph or like publication went up by 30% when it was allowed to cover the divorce courts. So that was the rationale in the original, for the 1975 Act, the modern Act. But it, in my view, it does absolutely need looking at, because we need to allow transparency. Survivors of abuse, survivors of the family court system need to be able to tell their story. There's very limited exceptions to being able to share story in public.
Thanks, Lyndall. I've got another one here that's of a more particular ilk. So one of our participants comes from an Islamic background, and in order to receive an Islamic divorce, she had to provide evidence about her ex-partner to the Islamic celebrant. Is this considered defamation?
Well, that might come within it. That might come within the qualified privilege defence. So where you're disclosing something to one particular person that where they've got an interest in receiving that information as well. So, for example, that covers when you're reporting to the police or authorities and that kind of thing. So if it may be that if this person has an interest in receiving that information for the purpose of giving evidence or whatever it was in relation to the family court case, that you'd fall within that qualified privilege defence.
Okay, lovely. Thank you, Jennifer. So I've got just to clarify a question. So this person has said, just to clarify, if no proceedings in the family law courts, the gag order would not apply at all, as long as publication is before any proceeding, as long as publication is made before any proceedings commence.
But I would remind that person about, I'll take them back to my initial part of the session, that if they've, please be mindful that they may end up in the family court and it can be used against them, right? It absolutely can be used against them. And when your ex is a domestic abuse perpetrator, they are looking for every single way to legally harass you. So be really mindful of what you're saying in any format, whether it's on a text message or social media, whatever it is. Just be mindful that you just might end up in the family court explaining to the judge why you thought that was in children's best interest, if there's children involved.
Thanks, Lyndall. We've got time for one more question because we will end on 8:30 tonight. So there was just, again, just a bit of a clarifier here. It says, well, the person who's asked it has said, a gag on the Federal Circuit Court case material only. So if you could just clarify that again, Lyndall, around the gag, how far it extends. Is it court case material only, or is it beyond that?
It's not just Federal Circuit Court of Australia, it's any action under the family law, right? So it's all family law courts, family law court, Federal Circuit Court of Australia. It's in any court across Australia, even if it's in a local court that's exercising family court jurisdiction. So it's the family law. If it's something that's relied on the family law, it's under section 121, and it's all material.
It's going to stop automatically. So I'm just going to say thank you so much to the both of you, and thanks everyone for coming. Please send through any other further questions, and expect our survey to come up, and also some recording and some fact sheets and slides to be shared. We hope that you have gained something from this. I know I have.
Thank you very much, Hayley. Thank you, Lyndall.
Thank you. Good night, everybody.
Good night, everyone. Thank you. Bye.